listed companies and prescribed companies, other companies will not have any audit committee. But in case of listed company and the prescribed companies, audit committee is required to be constituted. Let me just show you this particular slide to you, that there are certain companies apart from the listed company. Listed company, they must have the audit committee. Okay, audit committee is a committee formed from the board of directors, incorporating a maximum number of independent directors. I think I had explained that to you while I was talking about directors in my previous class when you were in second semester. But the thing is that in case of listed company, audit committee is a must. But if it is not a listed company, there are some other classes of company in which audit committee is required to be constituted. What are that particular type of companies? First of all, these companies are required to be unlisted public company. So listed company, so everything they require, they are supposed to have audit committee. But if it is a public company but unlisted, in that case, what are the criteria that must be fulfilled? Check the diagram here. Their paid up capital must be greater than or equal to rupees 10 crores. This is the first condition. The second condition is their turnover should be greater than or equal to 50 crores. And the third condition is their outstanding debt should be more than 50 crores as on the last audited financial statement. Okay, so these three conditions are mutually exclusive. So it doesn't mean that all the three conditions must be satisfied. If any one of the three conditions are satisfied, in that case, the company will be considered as a prescribed company, and in that situation, the company is required to constitute an audit committee. So, are you getting my point? So here, if it is not a listed company, if it is an unlisted public company, even then it may be required to constitute audit committee subject to fulfillment of any one of these three conditions. Let us look at one example here. ABC Limited, with paid up capital of rupees 8 crore and turnover of rupees 120 crore, is required to constitute an audit committee since the company falls under any one of the prescribed categories. So their paid up capital is 8 crore. So the first condition is not satisfied. But whenever I'm looking at the turnover, it is 120 crore. And what is the condition? They are required to have a turnover of 50 crore or more. So it is way more than 50 crore. So naturally, they are required to constitute audit committee. This concept, that which are the companies that are required to constitute audit committee, this is discussed under section 177 of the Companies Act. Now let us get back to my manner and procedure of selection. So I have already classified two companies, two sections, two categories within non-government companies. One category is those companies which are required to constitute audit committee, and those companies which are not required to constitute audit committee. So those companies which are required to constitute audit committee, they will do what? They will actually look into the qualifications and expertise uh, of the individual or the firm who are proposed to be considered for appointment and auditor are and are commensurate with the size and requirements of the company. So for those companies which are required to constitute audit committee, they will do this work. They will do what? They will actually select a panel of individuals or firms, and they will check that which auditor or which firm they will be commensurate with the requirements of our company. Because whenever you are a huge sized company, naturally your financial statements, your audit workload, they are also going to be really huge. So for the purpose of tackling this huge workload, you need a huge workforce from the audit firm as well. But if you are recruiting a very small audit firm, probably they will not be able to provide you with this adequate support. So for that reason, you need to select an appropriate auditor, maybe individual or a firm, who will be able to provide you with all the necessary support, and they will be able to do their work properly. So this is the work of the audit committee to check the expertise and the qualifications of the auditor and select the appropriate one. I am talking about selection, not appointment. They select the appropriate auditor. But in case of those companies in which audit committee is not required to be constituted, the whole work is done by the board of directors. Now, the audit committee or the board, they should consider any pending proceedings relating to the professional matters of conduct against the proposed auditor before the ICI or any competent authority. Now you know that if you ever follow the Chartered Accountants Act 1949, you will find that there are certain schedules of professional misconduct mentioned over there. So professional misconduct is something that are punishable offense. Okay, so any chartered accountant, be in practice or in service, they are not supposed to commit those professional misconduct. Otherwise, they will be punishable under the ICI regulation or the Chartered Accountants Act. So whenever the audit committee or the BOD, subject to the specific condition of the company, they select an individual or a firm as the auditor of the company, it is their responsibility to check all the pending cases against them. Do they have any pending cases of professional misconduct with ICI or with any other judiciary? So that is the thing that they must identify in the following step. Then the audit committee or the board, they may call for any other information from the proposed auditor. Suppose the audit committee is selecting an individual, or maybe in those companies where the audit committee is not required, the board is selecting an individual. What they will do, they will seek additional information from the proposed auditor, that I need this information from you. So they will provide the information. Then the audit committee or the board, they should recommend the name of an individual or a firm as auditor to the board or to the members respectively for consideration. What do I mean by this? Suppose I am talking about a company where audit committee is required to be constituted. So what will be the step over there? The audit committee will recommend the name to the board. The board will recommend the name to the shareholders. But in those companies in which audit committee is not required to be constituted, the whole activity is done by the board. So in those companies, the board will directly recommend the name to the shareholders of the company. Sorry. If the board agrees with the recommendation of the audit committee, it should further recommend the appointment of an individual or a firm as auditor to the members in the AGM. It should refer back the recommendation to the committee for reconsideration, citing reasons for such disagreement. So you see that in those companies where audit committee is present, whenever the audit committee is going to provide the recommendation to the board of directors, what the board of directors will do, they will check such recommendation. And if the board of directors likes the recommendation, they will forward it to the members. They will forward it to the shareholders of the company. But if they don't like that recommendation, in that case, they will actually send it back to the audit committee, and they will also have to provide the reasons that why they are not liking such recommendation. They have to provide these reasons for such disagreement. If the audit committee they decide not to reconsider its original recommendation after considering the reasons given by the board, the latter should record reasons for disagreement with the committee and send its own recommendation for consideration of the members in the AGM. So you try to understand the whole thing here. Suppose we are talking about some companies which are required to constitute audit committee. So I have already clarified you that uh, the listed companies and certain other prescribed companies, they are required to constitute audit committee. And the committees that are required to constitute audit committee, they are companies of economic significance. They actually influence the country's GDP. They actually influence the country's economic position. So if in these companies we have audit committee, audit committee has a very phenomenal role to play in appointment of the auditor. So what the audit committee is doing? Audit committee is first judging the individual auditor or the audit firm, and they are checking that whether everything is their quality, their expertise, they are appropriate for the requirement of the company. And accordingly, they are proposing the name to the board of directors. In between, if they need to have any information about any pending cases under ICI or any other further information, they can collect it, and finally they will decide about name and they will propose it to the board of directors. Board of directors, they will now check the recommendation made by the audit committee. And if they think that this recommendation is perfectly okay, then they will forward it to the members for appointment. Because ultimately, the members do not know anything about who should be the right person to be an auditor of the company. That is going to be decided by the management only, by the directors only. So, audit committee is basically a wing of the directors. So audit committee is giving a direction, audit committee is giving a recommendation to the board of directors. If the board of directors likes it, they will pass it on to the shareholders. But problem will arise if the board of directors do not like such recommendation. In that case, they will actually send it back to the audit committee for reconsideration, and they will also provide the reasons. But if the audit committee thinks that okay, their reasons are valid, so let us change the recommendation, that is one way of doing it. But if the audit committee thinks that no, the recommendation that we have made is perfectly okay, we don't have to change the recommendation now. In that case, the board of director, they will actually record the reason for disagreement with the audit committee, and they will now recommend their own person to the members, to the shareholders. Okay, so you see that why this particular system of audit committee came into place at the first place. Audit committee is actually a recommendation of the Cadbury committee. Okay, so back in 1990, after the Polytech International scandal, it was observed that the person who were recommended by the board to the members, they were actually controlled by the board. So if I recommend a particular person to be an auditor in my own company, and if I can control the person, naturally I can expect that the person is going to give his report in my favor. And that was happening in Polytech International. So when that particular thing happened, after that, the then UK government, the fraud was in UK, the then UK government, they have formed a Cadbury committee to give some recommendations about the changes in the corporate governance structure. So audit committee, implementation of audit committee is a phenomenal step in the corporate governance mechanism of the companies. Later on in our country too, we have adopted the same. So as audit committee is a committee with independent directors, they do not have anything to do with the organizational performance. So they do not care about the profit figure, they do not care about the organizational excellence of the company. So they can give their recommendation very freely. Okay. But if the board doesn't like such recommendation, if the board feels that if this particular auditor comes to our organization, they will be able to find out the financial manipulations that we have done in our company, and they will take adequate action. So the board may disagree with such recommendation, and the board may ask the audit committee to change such recommendation. But if the audit committee is also under the board's control, the audit committee may also change the recommendation. But if the audit committee is a committee with adequate integrity and objectivity, they may say that no, we are not going to change our recommendation. So naturally, the board will be in a problem. So in that situation, the board is going to provide their own recommendation to the shareholders because you need to appoint the auditors, but subject to the condition that you have to record the reasons for disagreement. Once you are recording, afterwards, if there is any investigation against the company, that investigator is going to find out that, okay, this is the reason for which the board has recommended his own member rather than opting for the member recommended by the audit committee. So naturally, this particular process has been made in this way to maintain the transparency in the whole system. But this particular concept cannot be implemented in those companies where audit committee is not required to be constituted. So in those companies, directly the board of director will select the person, they will recommend the name to the shareholders, and shareholders will appoint the person. No other thing, other hanky pankies will actually take place in that particular thing. The problem will take place only if the audit committee is constituted in a particular company. Any confusion, please let me know. কোনো কনফিউশন আছে কি যেটা বললাম?
No, sir.
So when based on the recommendations of the audit committee or the board of directors, the selection of auditor is finalized. Then the company is required to take a written consent and a certificate from the auditor to the effect that appointment is to be made as per the prescribed conditions and the auditor satisfies the criteria under section 141. So section 141 is about the eligibility and qualifications of the auditors. So you will be taking any auditor only if you find out that the auditor is fulfilling all the eligibility conditions. But only having this idea that auditor is fulfilling the eligibility conditions is not enough. You need to obtain a certificate from them as well in this particular regard, so that if later on it is proved that the auditor has falsified their positions, you can sue them in the court of law by citing that certificate. You have certified yourself that you don't have any problem, and right now the problem crops up. So I have a documentary evidence against you. So this is a very important document that you must collect. Now, question arises that what should be the content of the certificate? What you should actually incorporate in the certificate? This content of the certificate is discussed under section under Rule 4 of Companies Audit and Auditors Rules 2014. So here it is mentioned that the individual or the firm is eligible for appointment and is not disqualified for appointment under the Act, the Chartered Accountants Act 1949, and the rules or regulations made thereunder. So it's just like some declaration. Okay, whenever we fill up any form, we have to provide declaration at last. So it is also like a declaration that the individual auditor or the audit firm is going to provide their tick against this individual statements that there is no pending case against them. They are not disqualified under section under Chartered Accountants Act or the Companies Act or any other rules or regulations made under those two acts. The proposed appointment is as per the term provided under the Act. So Companies Act recognizes SA 210, that is for engagement of auditors. So in that particular essay, they have mentioned the terms of appointment. So this entire appointment should be made as per the appointment terms. That part should be also be certified by the auditor. The proposed appointment is within the limits laid down by the Act. So there are certain limits mentioned within which the appointment must take place. So that part should also be checked by the auditor. And finally, the list of proceedings against the auditor or audit firm or any partner of the audit firm pending with respect to professional misconduct is true and correct. So whenever the auditor is providing a list of pending proceedings against them, so it should not be falsified. They should not suppress any material fact. If any particular information is not given by the auditor and is disclosed later on or is discovered later on, then the company has the right to remove the auditor at instant. So that is the reason while the auditor is providing the certificate, they will have to take this individual statement based on which the company will be able to understand that okay, this auditor is well suited for appointment. Now, intimation to the auditors. Intimation to auditors. So, whenever you have decided that the company is going to appoint a particular person as an auditor, so you first have to intimate the auditor, okay, that he has been appointed in our company. And they are also supposed to file a notice to the registrar of companies within 15 days of the AGM. Okay, within 15 days, in the AGM in which the auditor has been appointed, within 15 days, you have to report to the ROC. And the form that you must use for the same is called ADT1 form. So what is the structure in which the appointment will take place? First of all, I have already stated the manner and procedure of appointment, how the audit committee recommends it, and how the board passes it on to the shareholders, and how the appointment takes place. So once the appointment is done, then the proposed auditor, they will provide their consent and certificate. When they provide their consent, then the company will appoint the auditor in the AGM. And after appointment, the company will inform the register within 15 days. So this is the structure in which the appointment will take place. So with this, I end my discussion on appointment of auditors. Now let me start with rotation of auditor. Rotation of auditor is under section 139 subsection 2. The following is the subsection under which the rotation of auditor would be discussed. So let us now look at the structure here. If the company has appointed an individual auditor, so I have appointed Mr. A as the auditor of my financial statements. So in that case, he will be eligible to be appointed in my company for one term. Each term is of 5 years. Okay, one term is of 5 years. So he will be eligible to be appointed for a period of one term of 5 years, after which there will be a cooling off period of 5 years again. So first I appoint Mr. A. He will serve my company as an auditor for a period of 5 years. Once the 5 years is complete, his term will end, and from that date, from up to another 5 years, he will not be eligible to be appointed in the same company. But if I'm talking about an audit firm, if I'm appointing PwC as the auditor of my company, they will be eligible to serve for two consecutive terms, of 5 years. So, what is the total period that they are eligible to serve our company? That is 10 years. So, they are eligible to serve our company for a period of 10 years, and here also the cooling off period is 5 years. So, after the term ends, I will not be able to appoint PwC once again for a period of 5 years. So, this is the structure of rotation of auditor. So this is what I have already stated. Let me just read it out once again. In case of individual auditor, no listed companies or other prescribed companies. I already mentioned no listed companies or other prescribed companies. One thing you must remember here, that the definition of prescribed companies for appointment of auditor is not same with that of prescribed company for rotation of auditor. While I said the prescribed companies for constitution of audit committee, the criteria that I have mentioned, they are not same as that of the criteria mentioned for rotation of auditor. So here don't confuse this, that whenever I say prescribed companies, don't think that in both the situations the conditions are going to be similar. Okay, the conditions are way different in case of rotation of auditor. But one thing that the main provision that you need to understand here, I will talk about the prescribed companies, which are the prescribed companies in case of rotation. But one thing that you must understand here, that no listed companies or other prescribed companies should appoint or reappoint an individual as auditor for more than one term of 5 consecutive years. So once 5 years is complete, he will not be eligible for appointment in the same company. The auditors who are appointed is not eligible for reappointment as auditor in the same company for 5 years from the completion of his term. So once the term is complete, 5 years, in that company it's not possible. In case of audit firm as auditor, the listed companies or other listed companies should not appoint or reappoint an audit firm as an auditor for more than two terms of 5 consecutive years, as I have already stated. The firms who are appointed is not eligible for reappointment in the same company for 5 years from the completion of the term. So once again, they have a cooling off period of 5 more years. MSPQR and Company, a chartered accountant firm, was appointed by Q Limited as the statutory auditor in its AGM for 12 years. Okay, the appointment was not valid, as the appointment can be made only for two consecutive terms of 5 years each, which also should not be made in the same AGM. There is also a cooling off period of 5 years after the completion of two terms. So while the appointment should have ended at the end of the 10th year, the firm has been appointed for 2 more years. So that is not at all allowed. So naturally, this particular appointment is void. Restriction on other audit firms having common partners. So this one is very interesting. So suppose an audit firm having a common partner or partners to another audit firm as on the date of the appointment, uh, and whose tenure has expired in a company in the immediately preceding the financial year should not be appointed as auditor of the same company for a period of 5 years. What do I mean by this? Let us look at the example to understand. Mrs. P, Mr. Q, and Mr. R are the partners of MSPQR and Company. Mr. R is also a partner of MSBCR and Company. Tenure of Mr. R has expired in the company immediately preceding the financial year. So, one particular company, they have appointed Mr. R as their auditor and his tenure has ended in the last preceding year. Now, the question is whether whether MSBCR and company will be qualified or not. So the answer is that they will not be qualified because when Mr. R was part of PQL Limited, PQL Limited was appointed as an auditor of a particular company. They have completed their term and their term has just ended in the preceding financial year. One of the partner of the company is also a partner of another firm. Now that company, if they want to appoint that firm in their financial year, that is not allowed because that partner is already associated with that particular firm. So why this particular provision has been created like this? The very reason why rotation of auditor has been implemented by the Companies Act 2013 is to stop a long run relationship between the auditor and the company's management. I think you will be able to agree with me that whenever the auditors are coming to audit the financial statements of a particular company, they will have to constantly interact with management members. And it's a common human psychology that after some point of time, they will be in close association with the management members. Now, if these auditors are appointed with the company for a period of for a huge period of time, after some point of time, they will develop a familiarity. Okay, they will develop a familiar relationship. So once I develop a familiar relationship with another person, it will be very difficult for me to give an adverse report against them. So that is the very reason why the concept of rotation has been implemented. Previously, when Companies Act 1956 was in place, there was no provision of rotation of auditor over there. But after the system scan, it was realized that PwC was associated with Custom in different capacities for more than 18 years. So this huge period of time, they have developed a very good relationship with the PWD management, and which could have been one of the reasons for which the auditors failed to exercise their independence in that particular company. So that is the reason why rotation is very important, and this is how you can implement it. So this is one of the provisions in which you will stop one partner of a firm which has just completed its term in one company uh, from getting appointed, being part of another company. So I was associated with Mr. R for the last 5 years. Now once again, I am appointing another firm in which Mr. R is a partner. Maybe Mr. R himself is not coming to me, but Mr. R will be in a position to influence the other partners who are part of that BCRM company. So naturally, if I want to stop this particular fiasco, I need to stop the entire firm from getting appointed in my company. So this is why this particular provision has been made in this way. Rotation for other prescribed companies, Rule 5 of CART. So, according to this particular rule, what they have mentioned is that if Any small company and any OPC, they are excluded from the concept of rotation. Any small company and any OPC. Why? Because it is believed that they are not in a position to influence the economic situation of the country, and the companies in which the auditing is very important, those companies are a class of companies that will be decided by the Companies Act only. And what are they? First is all the listed companies. In all the listed companies, you need to have the mechanism of rotation. So listed companies will have all sorts of regulation. That is a start. Then, if it is an unlisted company, then they must have a paid up share capital of rupees 10 crore or more. If it is a private limited company, then it should have a paid up share capital of 20 crore or more. And if all the companies apart from these two, if they do not have, if they have the paid up share capital below the threshold limit, but if they have the public borrowing from the financial institutions, banks, or public deposit worth rupees 50 crores or more, so even in that situation, they will be considered as prescribed companies. So prescribed companies are those companies in which the provisions for rotations will be strictly followed. And what are these companies? First one is listed company. Second one is unlisted public company with paid up capital of 10 crore or more. Third is unlisted private limited company with paid up capital of 20 crore or more. And fourth one is all companies which may not have the paid up capital limit for themselves. Maybe it's a public company where the paid up capital is less than 10 crore, or private company in which paid up capital is less than 20 crore. But if they have a borrowing, public borrowing from financial institutions or banks, or if they have any public deposit worth rupees 50 crore or more, they will all be eligible, they will all be considered for rotation of the auditors. They will also all have to mandatorily follow the provisions of rotation in their company. One example that I have given here, Tata Private Limited, a private limited company with a paid up capital of rupees 8 crores, but public borrowing from a nationalized banks and financial institutions of rupees 56 crore are a prescribed company eligible for rotation. Okay, so it's a private limited company. So the threshold is 20 crore. Threshold is 20 crore. Don't follow the diagram. The diagram, there is a typo. It should be 20 crore. 2 is missing here. So in this particular situation, it's a private limited company, so their paid up capital limit is 20 crore, but here actually the paid up capital is 8 crore. So naturally, they may not be eligible for rotation. But just because they have taken a loan of 56 crore, which is more than the threshold limit of 50 crore, they have to ensure the rotation in their own company. So there are so many other things that I must complete. So I will, from next day, I will start with time period for compliance for existing companies. It is also another interesting thing that I will complete here. Uh, Today it's already 2, so I'm not continuing any further. Let me take your attendance, then I shall end. But before that, let me ask whether you have any specific query with respect to my discussion today. কারো কোনো প্রশ্ন থাকলে করতে পারো. In fact, I want you to
Yes,
ask
sir.
me anything. আছে বলো.
Yes, sir. What is the meaning of cooling off for 5 years?
কুলিং অফ মানে হচ্ছে ঠান্ডা করা. মানে একটা অডিটর সে অ্যাপয়েন্টেড হয়েছিল, সে অ্যাপয়েন্টেড ছিল 5 বছরের জন্য. এবার তারপরে আমি তার সাথে যে রিলেশনশিপটা আমার হয়েছিল 5 বছরে, সেটাকে আমি ঠান্ডা করছি. মানে 5 বছর ধরে আমি তোমার মুখ দেখবো না. 5 বছর তুমি আমার সাথে কোনোভাবেই অ্যাসোসিয়েটেড থাকবে না. ইন এনি ক্যাপাসিটি ইউ উইল নট বি এলিজিবল টু বি অ্যাসোসিয়েটেড উইথ মাই কোম্পানি. দ্যাট ইজ কল্ড কুলিং অফ.
আচ্ছা স্যার, আপনি বললেন যদি ইন্ডিভিজুয়াল অডিটর হয় তাহলে সেক্ষেত্রে 5 ইয়ার্স অডিটর হিসেবে থাকতে পারবে, তারপরে 5 ইয়ার্স এর কুলিং অফ, তারপরে কি আবার উনি রিঅ্যাপয়েন্টমেন্ট হতে পারবেন ওই অডিটর
হ্যাঁ হ্যাঁ
ইন্ডিভিজুয়াল?
হ্যাঁ, পারবে 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 পারবে. মানে
ওকে স্যার,
প্রথম
থ্যাংক ইউ
পাঁচ
স্যার।
বছর প্রথমে অ্যাপয়েন্টেড হলো 5 বছরের জন্য, 5 বছর তারপরে কুলিং অফ চললো, তারপরে যখন সেই 5 বছরটা শেষ হলো, তারপরে সে আবার চাইলে রিঅ্যাপয়েন্টেড হতে পারে. ঠিক আছে?
ওকে স্যার, থ্যাংক ইউ স্যার।
আর কারো কোনো প্রশ্ন আছে?
হ্যালো স্যার, আপনি যে নোটটা আপলোড করেছেন,
হুম.
এটাই কি সেই নোটটারই শর্ট ফর্ম বা এরকম কিছু?
হ্যাঁ, নোট থেকে আমার লেখা নোট থেকে তো আমি প্রেজেন্টেশন বানাতেই পারি নাকি?
না স্যার, আমি এটা জিজ্ঞেস করি না, আমি বলছি ওই একই নোট নাকি আলাদা পাবে সেটা জানি।
হ্যাঁ, সিগনিফিকেন্টলি কিছু ডিফারেন্স নেই। সিগনিফিকেন্ট ডিফারেন্স কিছু নেই, টুকটাক কিছু কিছু জায়গায় আমি ইয়ে করেছি। একটা জাস্ট ছোট জিনিস, উইথ ইওর পারমিশন আমি একটু দেখিয়ে নিতে চাইছি। সেটা হচ্ছে যে যেটা আমি দেখাইনি, যে জিনিসগুলো আমি প্রেজেন্টেশনে দেখাই যেগুলো তো নোটসে দেওয়া সম্ভব না, সেটা হচ্ছে যে ফর্মটা বললাম না, ফর্ম এডিটি 1, যে ফর্মে রেজিস্ট্রারকে জানানো হয় যে আমরা অডিটর অ্যাপয়েন্ট করেছি, হচ্ছে এডিটি 1 ফর্ম। এই ফর্মটা এরকম দেখতে অনেকটা, ঠিক আছে? আশা করি তোমরা সবাই দেখতে পাচ্ছ এখানে কি কি থাকে। ইউ হ্যাভ টু প্রোভাইড ইউর কর্পোরেট আইডেন্টিটি নাম্বার, তারপরে নেম অফ দ্য কোম্পানি, অ্যাড্রেস, ইমেল আইডি, তারপরে বাকি যে ইনফরমেশন, ওয়েদার ইটস ফলিং আন্ডার জিএসটি অর নট, নেচার অফ অ্যাপয়েন্টমেন্ট, সেখানে ড্রপ ডাউনে কিরকম ভাবে আছে, তো ফার্স্ট অডিটর নাকি অ্যাপয়েন্টমেন্ট, রিঅ্যাপয়েন্টমেন্ট, অডিটর অ্যাপয়েন্ট ইন কেস অফ ক্যাজুয়াল ভ্যাকেন্সি, এগুলো সমস্ত ফিল আপ করা যায়, ঠিক আছে? এটা এডিটেবল পিডিএফ, এগুলো ফিল আপ করা যায়। নাম্বার অফ অডিটার্স টু বি অ্যাপয়েন্টেড, নাম্বার অফ অডিটার্সটা কেন দিয়েছে, অনেক সময় জয়েন্ট অডিট হয়, তো জয়েন্ট অডিট হলে বিভিন্ন ডিভিশনের জন্য বিভিন্ন অডিটর থাকে, তো সেটার জন্য সেইভাবে আহ, তোমাকে ইয়ে করতে হতে পারে, তোমাকে সেইভাবে জয়েন্ট অডিটর ঠিক করতে হতে পারে। তারপরে ক্যাটেগরি অফ অডিটর, ইন্ডিভিজুয়াল নাকি অডিটর ফর্ম, ইনকাম ট্যাক্স, তাদের যে ডিটেলস গুলো সেগুলো দেওয়া হয়েছে। এখনই যেও না, হ্যাঁ, আমার হয়নি এখন অ্যাটেন্ডেন্স নেওয়া, প্লিজ ডোন্ট লিভ এনিওয়ান। আমি জাস্ট এটা শো করে তারপরে আমি অ্যাটেন্ডেন্সটা নিচ্ছি। আহ, তারপরে তাদের মেম্বারশিপ নাম্বার, অ্যাড্রেস, পিরিয়ড অফ অ্যাকাউন্ট, সবকিছু, নাম্বার অফ ফাইন্যান্সিয়াল ইয়ার। আচ্ছা, এবার দেখো, লিমিটস অফ 20 কোম্পানিজ, অডিটর ইজ উইদিন দ্য লিমিটস অফ 20 কোম্পানি। বলছিলাম না লিমিট আছে কিনা, একটা প্রতিটা অডিটরের একটা 20 কোম্পানি ম্যাক্সিমাম সে অডিট করতে পারে আন্ডার সেকশন 141। এটা আমি বলবো যখন আমি স্কিলিং অন অডিটটা বলবো, সেখানটাই এই জিনিসটা বলবো। তো তারপরে সেখানে ইয়েস অথবা নো, যদি স্কিলিংটা এক্সিড করে যায় তাহলে সেক্ষেত্রে তুমি অ্যাপয়েন্টেড হতে পারবে না। তো তারপরে আরো কিছু ইনফরমেশন আছে যে কোথায় অ্যাপয়েন্টেড হয়েছে, এজিএম অ্যাপয়েন্টেড হয়েছে কিনা, কবে এজিএমটা হয়েছে, ডেট অফ অ্যাপয়েন্টমেন্ট। তারপরে আরো কিছু কিছু ইনফরমেশন, যেমন ওয়েদার দিস অ্যাপয়েন্টমেন্ট ইজ ডিউ টু ক্যাজুয়াল ভ্যাকেন্সি অর নট। ক্যাজুয়াল ভ্যাকেন্সি মানে হঠাৎ করে অডিটর মারা গেল, অথবা তার অডিট ফর্মটা উঠে গেল, তখন একজনকে অ্যাপয়েন্টমেন্ট করতে হবে, সেটা হচ্ছে কিনা। তো সেই জিনিসগুলো বলবে। এবং তারপরে ইউ নিড টু অ্যাটাচ সাম ডকুমেন্ট, ইনফরমেশন যেটা কোম্পানি দিচ্ছে সেটা অ্যাটাচ করতে হবে, রিটেন কনসেন্ট দিতে হবে, কপি অফ রেজলিউশন পাসড এট দ্য বোর্ড অফ দ্য কোম্পানি, লেটার অফ অ্যাপয়েন্টমেন্টটা দিতে হবে। এটা গভর্নমেন্ট কোম্পানির জন্য, এটা তো একটা স্ট্যান্ডার্ড ফরম্যাট, ইট ইজ ফলোড বাই বোথ গভর্নমেন্ট অ্যাজ ওয়েল অ্যাজ নন গভর্নমেন্ট কোম্পানি। তারপরে ডিক্লারেশন দিতে হবে, ডিক্লারেশনে এগুলোর সমস্ত যা দেওয়ার যা দিয়ে তারপরে সেটাকে তোমাকে ইয়ে করতে হবে। তো এটা একটা দেখানোর ছিল, ওটা ভুলে গেছিলাম দেখাতে, এটা দেখালাম। আর মৌসুম যে প্রশ্নটা করলো সেটা হচ্ছে যে আমার নোটস আমি যেটা দিয়েছি সেটাই স্ট্যান্ডার্ড নোটস, আমি সেইখান থেকেই প্রেজেন্টেশনটা বানিয়েছি, সুতরাং তার মধ্যে কোনো রকম সিগনিফিকেন্ট ডিফারেন্স কিছু নেই। কিন্তু এই যেরকম ফর্মটা দেখালাম বা টুকটাক কিছু এক্সাম্পল, সেগুলো আলাদা হতেই পারে, কিন্তু তার জন্য তোমাদের প্রিপারেশনে কোনো চেঞ্জেস হবে না। ইজ দ্যাট ওকে মৌসুম?
ইয়েস স্যার, অ্যাকচুয়ালি স্যার প্রেজেন্টেশনটা একটু বেশি ইজিলি আন্ডারস্ট্যান্ডেবল, মানে সেই জন্যই আমি বলছিলাম।
হ্যাঁ,
দেখি
সেটা
একবার।
ঠিক আছে, কিন্তু প্রেজেন্টেশনটা আমি শেয়ার করতে পারবো না, তোমরা তো লিখবে আনসার, তো সেখানে সেটাকে প্রেজেন্টেশনের মতো করে লিখলে তো হবে না, তোমাদেরকে তো যেভাবে আনসার লিখে বইয়ে সেভাবেই লিখতে হবে, তো সেই জন্য ওইভাবে দেওয়া হয়েছে, ঠিক আছে?
স্যার এই
ইয়েস
ফর্মটার
স্যার।
নেম কি বললেন?
এডিটি 1, এডিটি 1
ওকে স্যার।
দেখাচ্ছি দাঁড়া, ফর্ম নাম্বার এডিটি 1, ঠিক আছে? এই ফর্মে আরো কে জানাতে হয়। ওকে, তাহলে দাঁড়াও, হ্যাঁ, অ্যাটেন্ডেন্স নেওয়া হয়ে গেছে, থ্যাংক ইউ অল। আর কারো কোনো প্রশ্ন আছে? এখন আবার একটা কি ঢুকছে, আর কারো কোনো প্রশ্ন আছে? নেই?